Good afternoon, everybody. My name is Bruce Cooperman, and I'm pleased to introduce the fifth in the series of lectures in the Continuing Legal Education series, sponsored by American Friends of the Hebrew University in partnership with the American Association of Jewish Lawyers and Jurists. Today's topic, Heuristics and Biases and Court Decision-Making, is presented by Professor Doron Teichman, holder of the Jacob I. Berman Chair in Law at the Hebrew University Faculty of Law and former president of the Israeli Law and Economics Association. With research interests that include the economic and behavioral analysis of the law and empirical legal studies, Professor Teichman will share his insights into the seemingly irrelevant factors and inadmissible evidence that may impact sentencing decisions and damage awards. Studying the totality of inputs that may affect legal processes is among the many areas of study and analysis that can be found at the Hebrew University of Jerusalem Faculty of Law. Located at the university's Mount Scopus campus, the Faculty of Law was established in 1949 as the first law faculty at an Israeli university. Proud to count numerous Supreme Court justices, attorneys general, Knesset members, and leaders of Israel's legal profession among its distinguished alumni, the Faculty of Law has earned an international reputation for excellence, ranking 30th in the 2021 Shanghai Ranking of Law Schools and ranking first among Israeli law schools. The Shanghai Ranking Consultancy has also ranked the Hebrew University of Jerusalem 90th in its 2021 academic ranking of world universities, meaning that the Hebrew University is among the top 5% of universities around the world, as well as the leading university in Israel. American Friends of Hebrew University is proud to bring this lecture series to you as a part of our ongoing efforts to spotlight and support the academic excellence, cutting-edge research, and dynamic innovation that the Hebrew University provides in service to the state of Israel and people throughout the world. Now, during the course of the presentation by Professor Teichman, there will be some code words that appear on the screen, and you should be sure to jot those down, because if you're seeking continuing legal education credit, you'll need to use those words when you apply for that credit. We'll give you information about that at the conclusion of today's program. And before turning it over to Professor Teichman, I'd like to ask Milan Chatterjee, who's a representative of the American Association of Jewish Lawyers and Jurists, to say a few words on its behalf.
Thank you, Mr. Cooperman. Good afternoon, friends. My name is Milan Chatterjee. I'm a member of AFHU's Leadership, Empowerment, and Development Program. I'm also the Western Region Vice Chair of the American Association of Jewish Lawyers and Jurists, also known as the AHLJ. We are a legal organization that advances human rights and legal rights and civil rights in the Jewish community. We do so by filing amicus briefs on high-profile important cases affecting the Jewish community in the Court of Appeals and the US Supreme Court. We have an annual Pursuit of Justice Award where we've recognized America's leading jurists and attorneys for combating anti-Semitism and advancing civil rights in the Jewish community. Past recipients include Justice Ruth Bader Ginsburg, Justice Breyer, Justice Elena Kagan, and Attorney General Mike Casey. We've also acknowledged or recognized private sector attorneys, including our very own Patty Glazer. So very excited to be here. Before I hand it off to Professor Teichman, I did want to recognize some dignitaries who are here. So we have Nevada Supreme Court Justice Alyssa Kadish, who's also the Nevada State Chair for the AHLJ. She's been attending all of these CLEs, and we really appreciate her support. We also have Nathan Lewin and Aliza Lewin. They both are on the AHLJ board and are highly respected constitutional law attorneys. We also have Arthur Traldi, who's a very well-respected international law attorney and has been involved in filing a lot of AHLJ's amicus briefs at the US Supreme Court and various Court of Appeals. So thank you very much for being here, and I'd like to hand it off to Professor Teichman.
All right, good evening, everybody. Welcome. Thank you for this very kind and generous introduction, both introducing me and the law school that I come from. So yes, the topic today is going to be heuristics and biases in court decision-making. Let me share my slides with you and we can get started. So this is an area of research, of my research, basically, which focuses on the interaction, if you like, between law, decision-making, social psychology, behavioral economics. I study these topics both from the perspective of judicial decision-making or juror decision-making that we're going to talk about today, but in other aspects as well, contracting behavior, criminal behavior, compliance, and things of that sort. But again, the topic for today is going to be heuristics and biases in court decision-making. A quick outline of the plan for today, and we'll just see kind of how time allows us to do all of this, is basically to give you just a bit of a tasting menu of some of the key main psychological findings and to demonstrate their application in very concrete legal contexts. So I'm going to talk about the anchoring effect, the compromise effect, the hindsight bias, inadmissible evidence, or the ability or inability of courts to ignore that evidence, and a little bit at the end on cognitive depletion. I'm going to explain every one of these terms. You might be familiar with some of them, but everything I'll kind of explain throughout the talk. I don't assume that you come with prior knowledge of these issues to the talk. So let's start with anchoring. Anchoring is basically people's tendency to give excessive weight to a salient figure when they make a numeric decision, right? So some factor in the decision-making environment elevates a certain number to be more kind of in your eyes, in your face, in the presence, and as a result, you basically give it extra weight when you make that decision. The classic study, early study, I should say, from the 1970s, which actually was conducted at Hebrew University. This is a project of Daniel Kahneman, who later on received the Nobel Prize, and Amos Tversky, and those of you, again, familiar with their work probably know that it started at the Hebrew University. So they studied this phenomena, and they asked their participants in the study, what is the percentage of African countries in the United Nations? A kind of factual question that most people don't know the precise answer to. The interesting thing is that what they did is before they asked them this questions, they put into the room a wheel of fortune, and they spun the wheel of fortune, and the wheel of fortune was rigged in a way that for half of the subject, it always came out at the number 10, and for half of the subjects, it always came out at the number 65. So they asked them, do you think that number, that percentage, is it higher or lower than 10? Or is it higher or lower than 65? And people gave an answer to that question. And then they gave their final estimate, what is the percentage of African countries in the United Nations? And the thing is that these completely random numbers, and the nice, elegant thing, if you'd like, about the study is that by design, this is a meaningless number. This is a number that came out on the Wheel of Fortune, caused people to alter their estimations of this factual questions dramatically. Those who looked first at the number 10, who got that number in their head, gave an estimate of 25. Those who got the number 65 stuck in their head gave an estimate of 45. There's a huge body of literature documenting the anchoring effect since the 1970s. So just to highlight a few points here, experts are subjects to this issue as well. So I'll talk about jurists in a moment, but real estate brokers and other experts as well when they get their evaluations. There are other applications that are interesting, and we could discuss perhaps at the Q&A aside from the judicial decision-making aspect that I'm going to talk about today. So in negotiations, for example, the anchoring effect is tied to the first mover advantage. If you are a transactional lawyer and have the advantage of simply putting the first number on the table, the anchor from which the negotiation then continues, studies have shown that even if we leave that anchor, it has a gravitational force. Whoever puts the first number on the table has an advantage in the negotiation process. So that is just one example of an additional application of this finding that I'm talking about today. But again, what I want to focus on is applications in the judicial decision-making context. And what I'm going to start with is where most of this literature is at, and that is the numeric outcomes of trials. So right, recall, anchoring is about salient numbers. And judicial decisions often end up with a numeric decision, most notably, if we're talking about civil litigation, we're talking about damages. And if we're talking about criminal litigation, we're talking about some type of sentencing. So social psychologists have estimated that, or hypothesized that this effect might impact those types of decisions made by courts. So here are a couple of studies documenting this. And the nice thing about both the first studies that I'm going to tell you about here is that they were conducted actually not with jurors, but rather with professional judges. So this first study covered the topic of criminal sentencing. The subjects here were German judges, so a bunch of really, really serious people. The design is very simple. People read a description of a case, and then they're asked to render a sentence. And there's an anchor, and the anchor is very similar actually to the Kahneman and Tversky design, right? People roll a dice, and the dice is rigged to come out either at 3 or 9, and then the judges are asked beforehand, do you think 3 months or 9 months is an appropriate sentence for this case? And then they're asked the actual outcome. Okay, what do you think is the appropriate sentence for the case? And the result is, right, the judges who first thought about the number 9 give an answer of 7.81 months as the appropriate penal response to the case. And those who simply thought about the number 3 beforehand, and again, these are just random numbers, give this statistically significantly lower sentence here, simply because the roll of the dice was to a lower number. Another paper taking a slightly different approach, and these 3 authors, who are American authors, some of you might be familiar with their names, Guthrie, Richlinsky, and Ristrich, made many of the path-breaking studies, or wrote many of the path-breaking studies in this field. So they study the topic of damages in civil litigation. Their design is different, and if you ask me personally, I prefer it in the sense that throwing die and kind of doing a wheel of fortune almost turns these experiments into games. They actually have an experiment that feels much more like a legal case. So their subjects are US judges. The way they anchored their subjects is, again, in a, I think, more sophisticated way. What they did is they included in their materials a frivolous motion to dismiss the case. So the point was, the case involved personal damages that were very high. They were in the hundreds of thousands of dollars. And then all they added was that half of their judges saw a preliminary motion saying that the case doesn't meet the jurisdictional threshold because of the amount of money involved. But the point is that the jurisdictional threshold was so low that it was clear that this was frivolous. So the nice thing about it is that the judges considered this motion. They unanimously rejected this motion, right? So the motion said, okay, this case is only about $50,000. You should reject it because it's so low. But then after they rejected that, they moved to make the actual damage determination. Liability was conceded in this case. And you can see here, this is the group with no anchor and with anchor, and these are the distributions, but the repeating finding is that the no anchor group, right, people who were not exposed to this frivolous motion, gave significantly higher damage awards, right? These are professional judges evaluating kind of actual court materials. So simply introducing to them a frivolous motion, telling them that the damages are really, really ridiculously low. The judges, all of them, unanimously reject this motion, but still this frivolous motion pulls them downward because it got that low number into their minds before they made their ultimate decisions. So just a kind of overall look of this body of literature, and I should say, I just kind of selectively chose here 2 papers, one from Europe, one from the US, one dealing with civil damages, one dealing with criminal sentencing. This is a large body of literature documenting again and again the same finding that I described here. Now using, again, different manipulations, different stories, different nuances, and different contexts. But the general result coming out of this body of work is, if you'd like to, collapse it into a sentence, the more you ask, the more you get, right? These high anchors kind of pull the damage awards or the sentencing decisions upwards. This does create a dilemma for defense lawyers that I'm just going to put out there and leave it as a dilemma, in the sense of, what do we do about this? Do you counter anchor, right? So there are some studies suggesting that, if you introduce another anchor into a low anchor into this decision-making environment, you might counteract the effect of the high anchor. But of course, that has a more deeper that's a bigger decision in the process of litigation. Do you want to put a number on the table as a defense attorney, or do you want to say simply that the appropriate number is 0 and not some other low number? So I'm just going to leave this as a dilemma out there and move to describe one of my studies as well. So this is a study that I wrote with 2 colleagues, 2 Israeli colleagues, Yuval Feldman from Bar Ilan, Amos Shor, he's from the business school at Be'er Sheva. And what we tried to do in this study, published in the Journal of Empirical Legal Studies, was to extend the body of work on anchoring to show that anchoring is not only about damages and sentencing, but also about the actual decisions that people make about liability itself. So many times, liability decisions, the substantive decisions of the law, also rely on a numeric scale. And what we show in this study is that those decisions regarding liability also could be impacted by a irrelevant anchor. So an example, I'm not going to show in detail here, but for example, we had a study conducted with corporate lawyers in Israel that they needed to evaluate what would be a reasonable amount of dividend distribution under corporate law. There's a standard that limits the corporation's ability to distribute dividends under Israeli corporate law. We added just erratic anchors into their decision-making environment, and we could sway their professional estimate of what is reasonable risk for the corporation's solvency up and down just with those wild anchors. This is another example of one of the studies we conducted in this paper. So this is a comparative negligence case. You don't need to read all the text, but basically the story here is of an accident, an auto pedestrian accident in which both parties are somewhat to blame. We designed it intentionally, pre-testing it in a way that the driver was mostly responsible. The pedestrian was somewhat responsible for the accident. And now to the interesting manipulation here, right? So half of our subjects were simply given standard jury instructions on comparative negligence and asked to decide, what's the percentage that would reflect the proper responsibility, share of responsibility of the plaintiff in this regard being the pedestrian, again, has the lower fault. The other half of the people were told that they live in a 50% comparative fault jurisdiction. That is that if the plaintiff is more than 50% responsible, then they're off the hook, then they don't need to pay anything. And then there was a motion by the defense saying that the pedestrian was more than 50% responsible. Now, as I noted, by design, our pedestrian was less than 50%. We designed the materials that way. And consequently, when faced with this question, do you think that the plaintiff is more than 50% responsible for the accident? The unanimous answer was no, right? And those were the facts of the case. But then we asked them the exact same question, right? In your opinion, what percent of responsibility best reflects the plaintiff's share of fault, right? Which is the exact same question we asked people in the other group, but they were not asked the 50% question. And the interesting result that you can see here, right, with the anchor, asking them about 50% beforehand pushed their estimates, almost double their estimates of the relative fault of the pedestrians simply because we got the number, the high number, the 50% number into their minds when making this decision. Now, you know, there could be arguments for or against the 50% rule. Some of you that, you know, doing tort litigation might be familiar with that theoretical literature. But the point is that this can't be a good result of that rule. Using that rule as an erratic anchor to push comparative fault judgments upwards seems to be a complete misuse of the rule, and this is something to kind of take note of in this regard. And I should say the subjects in this study were advanced kind of 2Ls, 3Ls at Columbia Law School. So this is not like, you know, we're managing just to kind of fool people who are clueless about this. These were kind of sophisticated people with legal training. All right, that was the kind of, as part of our tasting menu evening, that was our first bite, getting to know a little bit of the anchoring effect, the research done in the area. A second phenomenon I'd like to introduce to you guys this evening is the compromise effect. Rational choice theory, if you like, the competing theory to behavioral theories that I focus on, basically assumes that preferences or decisions are context independent. That is, the ranking of two options should not be influenced by the availability of additional options. This sounds a little bit abstract, so let me be a little bit more concrete so things become more clear. The compromise effect suggests that people like the middle ground. So adding options to the menu and situating a certain option as the middle option, that alone will cause that option to be more popular, to seem more desirable by people. So the classic, again, psychological study in this regard was published by Simonson and Tversky in 1992. So here's the experiment. So people are given a dilemma, a consumer choice, to choose either a low-level camera or a medium-level camera. And I'm sure this was pre-tested and by design. This is no coincidence. The results that they had were that, you know, 50% of people wanted the low-level camera and 50% of people wanted the medium-level camera. You know, and as economists, we have nothing to judge about people's preferences in this regard. There's nothing rational or irrational here. These are simply people's preferences. Now comes the interesting point. In the second condition of the experiment, the second group of the experiment were given a menu of three options: the low-level camera, the medium-level camera, and the high-level camera. Now, this is a bit of a nuanced point, but I want to stress it. So assuming everybody here is rational in this experiment, adding the high-level camera, which is, of course, a more expensive camera, what I want you to note is that, of course, this third option could impact the demand, excuse me, for medium-level cameras. It would be completely reasonable to see people saying, oh, I bought the medium-level camera, but I'd be happy to spend more money and buy the more expensive camera. That makes sense. But, and this is the important point, adding this third option here should not matter at all to the demand for low-level cameras, right? People should not be moving and buying the medium-level camera now because the high-level camera is available if their dilemma was between the low-level camera and the medium-level camera. Those two options were on the table beforehand, and adding the third option is a completely irrelevant addition to the decision-making environment from the perspective of those people who chose the low-level camera. Having said that, with this long introduction, right, what you can see is when we added the high-level camera, what happened is that there was a significant drop in the demand for low-level cameras. So the reasonable conclusion from this is that people trickled from the low-level camera to the medium-level camera. There's something nice about the middle ground that makes us feel comfortable, that caused people to simply shift their preferences by adding this irrelevant option. Now, the people doing marketing, and many of the stuff that I'm talking about today is the bread and butter of marketing in business schools. And part of the point when I teach an entire class about this in law school is that, the things that these things studied at business schools are relevant for lawyers as well. Right, so there's an entire science that some of you might be familiar with about designing wine menus in restaurants. And the point of, some of the points here is, for example, adding something like this highly expensive wine at the bottom of this wine menu. The reason this wine is there, most likely, I'm not sure about this, this is speculation, is not to cause people to order this bottle of wine. Probably hardly anybody orders it. But what it does is it pulls people downward in the menu towards the more expensive bottles of wine. So this is kind of the science of creating a menu. There are other implications about this also that are outside of the menu that I'm not going to discuss in great detail, but I don't know if any of you have ever read a legal opinion by the retired Justice Aaron Barak of the Israeli Supreme Court. Aaron Barak was a master of the compromise effect. Aaron Barak would always, if there was, or always, in many of his kind of momentous rulings, would tell us, oh, this is a dilemma. There are three options here. There's this option, there's this option, and there's the middle ground option, this reasonable option, that this is the option that I am adopting in my ruling. He would do that all the time. And of course, there's a lot of power to that rhetoric, right? It's very convincing. Having said that, of course, I hope we all understand that within the legal terrain, it's very easy to always design these menus and present your argument, your theory as the one that is the middle ground, the reasonable option. So here's one example of how this plays out in a more kind of systematic experimental setting in a legal setting. So this paper published in the Journal of Legal Studies in 1996 had participants read materials about a criminal case. It involved a homicide. It was a domestic homicide. The defendant used sleeping pills in order to kill her husband. She did this after overhearing her daughter basically talking about how her current husband, the daughter's stepfather, was sexually assaulting her. So these are the materials of the case. This is what people were asked to analyze. And again, the menu. So half of them faced a menu in which the two options on the table were either manslaughter or murder, right? And the division was 47% decided manslaughter, 53% chose murder. The second group of the experiment were given actually three options. They were given the option of manslaughter, murder, and special circumstances murder. That is murder that is especially gruesome and caused special suffering to the victim in the process of causing their death. Now notice the interesting aspect of this design, and that is that the difference between manslaughter, adding special circumstances murder to the menu should not impact the decision between manslaughter and murder. And why is that? For those of you kind of Crim Law 101 who haven't done Crim Law for a while, the dividing line between manslaughter and murder has to do with mens rea, with the state of mind of the defendant during the time of the homicide, right? Was she so overwhelmed by the conversation that she overheard that she did not have the required state of mind for murder, and as a result, we will convict her only of manslaughter, of the lesser crime. On the other hand, the threshold between murder and special circumstances murder is part of the objective elements of the crime. It has to do with the suffering of the victim. It had nothing to do with the state of mind of the defendant. So adding special circumstances murder should not impact the amount of people deciding that she didn't have the sufficient mens rea for manslaughter. Having said that, much like the previous consumer choice study I presented, adding this option to the table diminishes the demand for manslaughter. causes people to move from manslaughter to murder. Again, I'm not talking about people moving from murder to special circumstances murder. There's nothing irrational about that. The thing that should not happen is people moving from manslaughter to murder. So we can understand from this that the creation of the legal menu, the options put on the table, is going to have a significant impact on the decisions that judges or jurors make. And as I mentioned earlier, there's a lot of rhetorical power as well in situating your argument, your theory, your legal theory as the middle ground theory, and making it in that way the more convincing theory. All right, here's our first keyword for the evening: technique. All right, hope everybody caught that. Let's move forward to the next item in our tasting menu for the evening, and that is the hindsight bias. This I hope that perhaps many of you are familiar with already, but I want to kind of present to you in a more systematic way the studies from the area. So the hindsight bias alludes to people's tendency to systematically overestimate probabilities once they are asked to do that in retrospect. In more plain words, that means that we are all Monday morning quarterbacks. We all knew this all along. Once we are told that something has actually happened, we overestimate the probability that that thing would have happened. The classic example here, and by the way, again, this is kind of a, Hebrew U Hall of Fame, and this area is an area in which Hebrew U is a powerhouse. So Baruch Fischhoff, this classic study of his from 1975, again, conducted at Hebrew U. Again, this was the era of Amos Tversky, Daniel Kahneman, and Baruch Fischhoff is one of their leading students. So this is his classic study documenting the hindsight bias. So he asked people to estimate probabilities regarding the Gurkha War between Great Britain and the Gurkha tribe in Nepal. And there are three conditions in the experiment. One is a control group, that they simply get factual descriptions of the pros and cons of each group. The Gurkha like to have the home turf advantage, they know the terrain, etc. Great Britain has greater armies, greater technology. It gives them all the information, and they're supposed to give probability estimates as to who's going to win this war. Group A is then given the exact same facts, but are told that Great Britain won. Group B is given the exact same facts, and they are told that the Gurkha won. And the results that we get is that, of course, Group A overestimates the probability that Great Britain will win the war. Group B overestimates the probability that the Gurkha will win the war. This is this hindsight. Once you are told what happened, you overestimate the probability that it will actually happen. There are, again, hundreds of studies documenting this phenomenon by this point, very robust studies. Some of them are within subject studies. So we asked the same people prior to the presidential election, what do you think is the probability that Donald Trump will win the election? Then we ask the same people after Donald Trump wins the election, if I would have to ask you to estimate the probability of Donald Trump winning, what number would you put on it? And after the event happens, suddenly people elevate their own probability estimates. Professionals are subjects to this as well. There are studies with doctors, with accountants, and other professions as well. Group decision-making doesn't really change this, so groups are subject to this type of decision-making as well. Again, as of 2012, this is the recent review study. There are more than 800 papers on the bias. And again, each paper usually includes more than one study, so we're probably talking about thousands of experiments, published experiments by this point. A meta-analyses were produced in 1991 and 94, in 2004. And again, this is heavily cited within the legal literature. Lawyers, judges are aware of this phenomena. There are a few theories explaining what's going on here. Some of them are cognitive, kind of just the way we think. So the point is basically, once this information gets into our mind, we can't take it out of our mind, right? Our mind is not built to remove from itself information that is relevant information. And other aspects here are motivational, right? So I simply want to think of myself as smarter than everybody else. So once I know that something happened, that Great Britain won the war, then, oh, of course I knew that. I knew that all along. I'm smarter than everybody else. So there's this motivational aspect of the bias as well. Turning to the law, right? So this phenomena was initially, as I mentioned, not studied in legal contexts, but it does have significant legal implications. So the classic study here is by Kamin and Rachlinsky from 1995. Basically what they do is, again, present the identical fact patterns about the risk. The risk here is the risk of a flood that could impact a municipality. Their materials are based on an actual court case involving such a flood. In the foresight condition, they give they ask people to read this material and then assess the reasonableness of the municipality's decision whether or not to take a certain precaution to prevent the flood. In the hindsight condition, they give them the exact same precaution and the exact same legal standard. So they give them the exact same definition of reasonableness, but they're asking them to evaluate reasonableness in the context of tort litigation in which the flood has already occurred. They know that, right? This is a hindsight condition. And the interesting thing here is that, right, in the foresight condition, only 24% of the people think 24% of the people think that not taking the precaution is unreasonable. In the tort litigation context, 56.9% of the people now think that not taking the precaution is something that is unreasonable. And this even affects their probability estimates, right? So they're simply, the estimate that they put, the numeric estimate of the likelihood of the flood increases once they know that the flood actually happened. What are the implications of this? What does this mean in actuality? So in actuality, this could mean that negligence is much closer to strict liability, right? We call it negligence, but many times courts find negligence, not when there really is negligence, but when they're simply operating in hindsight and they're raising the bar to a level that basically people cannot withstand. And as a result, they're finding everybody liable and negligence turns into a strict liability regime. From a normative perspective, this might not be a terrible problem if it really works the way that I just described, in the sense that simply everybody is found liable. And the reason for that is that there's a robust economic literature suggesting that a strict liability regime actually creates good, efficient incentives for people to take optimal care. The more likely and problematic situation is that it doesn't turn into a strict liability regime. It simply means that the courts set a higher threshold and then people try to live up to this higher threshold. So courts demand from people inefficiently high levels of precaution simply because they're judging in hindsight. And then people understand this. People ex ante understand that ex post courts are going to impose the super high standard, and therefore they take excessive care beforehand as a result of the hindsight bias. All right, a word about debiasing, right? So maybe we can deal with this through debiasing. Maybe we just need to explain to judges and jurors about this. So the gist of the matter is that debiasing is unsuccessful. Monetary incentives don't work. It's not really relevant with respect to judges or jurors, but in experiments you can do that, and it's been shown not to be effective. Alerting people to the phenomenon, again, that alone doesn't really work as well. A meta-analysis, that is one study that compiled all existing studies of 100 hindsight studies, concluded that manipulations to reduce hindsight bias did not result in a significantly smaller effect size. In Kamin and Rachlinsky, 1995, they had this debiasing manipulation, right? So they added in one of their experimental treatments this text. Making a fair determination of probability may be difficult. As we all know, hindsight vision is always 20/20. Therefore, it is extremely important that before you determine the probability of the outcome that did occur, you fully explore all other possible alternatives. Please take a moment to think of all the ways in which the event in question may have happened differently or not at all. After this, basically, people subject to the debiasing treatment, 15 out of 26 found liability. With the treatment, 14 out of 25. Basically, this means zero effect. Nothing happened, and this debiasing treatment didn't work at all. Some treatments might work a little bit better, but again, basically, there's a limited success on this. One final note here about this. One possibility to think about is maybe we just need to not use the negligence standard, and as a result of that, and then kind of solve our a problem with hindsight by simply not using a negligence standard. That might be the case in the corporate arena when we talk about the business judgment rule. Again, for those of you working in the arena, this might be one of the explanations for that rule, right? The idea is that simply taking risks in the corporate arena is something that is actually good for shareholders. Courts judging this risk in hindsight are going to make systematic mistakes. So what we actually want in that arena is simply not to have a negligence rule at all. And what we do is use the business judgment rule as a result. In tort law, of course, that would be terrible, right? Because we would have excessive risk-taking, a lot of accidents. In the corporate arena, there are alternative mechanisms that could help overcome the problems of corporate misconduct. And as a result, this might be a good idea in that very specific context. And therefore, this behavioral story might be part of the explanation for the business judgment rule. I see the time is flying. So I think what I'm going to do is actually skip this and dedicate the last 5 minutes to one final different topic. So our second word of the day, I should say, is evidence, and this will function as a gateway to our final topic that has to do with mental depletion. So evidence is the second word of the day. Okay, so I want to talk about this at some level for the, shock value of the study. This study made a big splash, both in the academic circles. It was published in the Proceedings of the National Academy of Science, one of the top 3 science journals in the world, together with Science and Nature. It made a big splash when it hit the press. It was covered by the popular press. Not, as you'll see in a moment, it's an Israeli study, but not only in Israel, it was covered across the world. And well, spoiler alert already now, I think it's a bad study, and I'll explain why in a second. All right, so this study basically explores the impact of coffee breaks or snack breaks on the decision of actual judges, right? So this is not experiments. These are actual decisions made by panels. These are parole decisions made by Israeli judges. They have basically 2 options, either to accept or reject. The session is divided by 3 coffee breaks, to 3 by a coffee break and a lunch break. And they have 2 hypotheses in this paper. One is mental depletion. That is, as people get tired, and you can think about yourselves getting tired as well, perhaps at this point of this talk, they move to easy decisions. You just, I'm so exhausted. I just want to make the easiest decision possible. Their second hypothesis is that rejection decisions, that is rejecting the request for parole and basically leaving the inmates in jail, is the easier decision. That's kind of not changing the status quo. They're just saying, rejected, come back in a month. That's the easier decision to make, as opposed to kind of actually saying why they're releasing somebody from jail. So these are their 2 hypotheses. Thus, their key presumption here is, right, as we move forward in time in each session, we're going to see a decline in the amount of people that their parole requests are being accepted, and rejections are going to go up. So here's the picture, right? This is taken from the paper. This is, when the judges just come, in the morning right after they had breakfast. Things are looking pretty good. And as the day moves on towards the coffee break, you can see that people over here, they're staying in jail. Then they go to their coffee break, oops, again, things are looking good. People are getting out of jail, moving towards lunch, they're getting exhausted. They're keeping people in jail. You don't want to be one of these cases over here or over here. Then, they're back from lunch. They're not hungry anymore. People are getting out of jail. And as time progresses, again, you don't want to be one of these cases over here that's standing between the judge and getting back home. So as you can see, right, this is a very sexy result. This is kind of made a lot of impact. And again, this is not an experiment. These are actual decisions, parole decisions made by Israeli judges. They control for different factors like sex, nationality, criminal record, rehabilitation, years served, etc. Having said that, seems like a neat experiment. When I teach this paper in my class, I teach it under the rubric of bad science, of here's how not to conduct an empirical legal research. And what's the problem here? What's the error in this study? This study makes one key assumption. And that assumption is that the order of the cases here in this line is random, right? It's the luck of the draw, whether you're this first case over here or you're your last case over here. The only thing impacting is the things that they control for over here and whether the judge is hungry and thirsty or not. But the thing is that, I don't know, anybody here who clerked knows this, and I understand there are a few even judges in the room. The order is non-random. And we know that routinely, and there are many unobservable factors that judges kind of, when they stack the pile and decide what they're going to deal with first, impacts their decision. And just to name one factor that my colleague from the faculty, Karen Weinschel, has already documented that impacted the ordering effect here, is the question, do people have lawyers or not? Because the way these hearings work is that they're actually conducted in the prison. And lawyers representing people come to the prison. And what happens is that some of the inmates have lawyers, some of them don't. And the time of the inmates has no value in this scheme, right? Because they're staying in jail overnight no matter what. But the time of the lawyers is very valuable. So basically what happens in these hearings is that the judges ask, okay, who has a lawyer? Okay, all the people with the lawyer to the head of the line. Right, so the people here, here, and here are people with legal representation. The people here, here, and here are people without legal representation. So that alone drives a huge chunk of the results over here. So this is a really interesting, sexy result, if you like, that kind of catches the eye. And again, I've been to cocktails in which people were talking about this paper, but you actually need to read it in a critical way and understand the problem associated with it. Let me just add some concluding remarks, and we'll have like 10 minutes for Q&A. The general picture from the body of research I reviewed today is that heuristics and biases do impact court decision-making and a long area of topics. There are external validity issues to the studies I described. So some studies, my colleague from the Hebrew U, Adi Leibovich, is actually conducting more and more studies with actual studying the actual decisions judges make in court. Most of the studies are conducted by experiments, and there are external validity questions and experiments. To what degree do these experiments reflect what's happening actually in the courtroom? And that's something that should be acknowledged. There's the question of comparing judges and jurors. There are actually not many studies who give an answer to the question, these biases, comparing exactly the same material, judges and jurors. There are a couple of studies doing that with hindsights, showing that jurors are more susceptible to the bias than professional judges, but we don't have a lot of studies doing that. Accountability is another big question, right? To the extent people are accountable, to the extent, for example, the judge writes an opinion explaining why they decided the way they decided, perhaps the level of biases will decrease as a result of that. And there are studies suggesting that accountability does matter. And finally, something that I suggest to think about is to start distinguishing between different types of decisions that judges are making. Some decisions are very slow, deliberate, and those decisions might less be impacted by heuristics and biases. And some are very kind of quick and off the bat, and things like that might be more susceptible to heuristics and biases. To the extent any of what I said tonight or this evening was interesting, you're all invited to take a look at my book with my co-author Eyal Zamir, Behavioral Law and Economics. It came out in 2018, published by Oxford University Press. And I'll just quote here, Cass Sunstein from Harvard Law School, describing it as brilliant and comprehensive. And there's nothing like it. So others have said that. I dare not say that about my own book. All right, I'll stop here and we can do some Q&A.
So we do have some questions here. Going back to the talk about the compromise effect, were individuals who changed their views in these studies ever interviewed? The question asker is wondering if people are drawing inferences about information not available to them. For instance, in the case of the cameras, concluding that the extreme low place in the market of the cheap camera reflects a manufacturing or chain supply imperfection that they would like to avoid.
Yeah, so there are different explanations as to why the effect is happening. So first of all, as to the first question, I'm not familiar, or at least the studies that I've cited here, they didn't do post hoc interviews with people. And some of the arguments are, and this is a very typical kind of response to a behavioral phenomena, and that is that, look, it's not really irrational, it's rational. There's an information story about here, there's some kind of rational explanation to what's going on, and the explanation given here, there's something to it. I completely understand it in the sense that, you're deducing something from the comparative place in the market. Having said that, and especially actually in the context, like the legal context that we talked here, to the extent the menu can be reproduced in as many ways as possible. You have, people that the creator of the menu has full discretion in this regard. And again, even if you think about the marketplace, right, and going back to the wine menu, the universe of wine is so great that whatever I call here as low level wine, there's still, that $2.99 bottle of wine that I can go down to. So it's difficult to infer from that regard. And again, there's just the aspect of just understanding of the power of the menu and the power of the person designing the menu and deciding what means a low quality product.
Okay, the next question is when you were talking about sort of the coffee breaks, how about judges who have had a couple of drinks for lunch? Has anyone studied that?
I'm not familiar with somebody studying that. I should say, studying judges, I can share my grief with everybody here for a couple of minutes, in the sense that just this last week, I personally am not signed on a single study studying judges. And the reason for that is that Israeli judges are completely non-cooperative with participating in such studies, while American judges are totally fine with that. So, this week, early on, I was in a, judicial seminar here in Tel Aviv. In March, I'm personally organizing a judicial seminar in Jerusalem. And in the US, the routine deal is I'll do this for you and you participate in my studies. And in Israel, it's please do this for us. Come give us a talk about, heuristics and biases in court decision making, but we're not going to help you in your studies. So I'd be very happy to give them, drinks and cocktails in just the moment before my talk, and do that randomly to some of the judges and not to others. I don't think that's going to happen, and certainly not in Israel, regretfully.
Another question about the anchoring effect. Does it negate the common advice never to make the first offer, or does that advice also have a role to play?
No, so actually the common advice coming out from the anchoring studies is to put the first number on the table. That's the standard kind of insight. Again, the business school insight. Is that whoever puts the first number on the table has an advantage, because that's the anchor, and the ultimate number will gravitate, even if both parties understand that the first number is an unreasonable number. They will gravitate towards that number. And there's even a discussion in some of, kind of marketing business school textbooks of what do you do if, the first number is just like an outrageous number, and you need to somehow like take it off the table, like to leave the room or something, and say like, we're going to start over like this, because once you agree to start the negotiation based on that high anchor, even if you're saying it's like your counter offering, the final point of the negotiation is going to be closer to the point to whoever put the first number on the table.
Okay, I think we have time for one more quick question. So on the parole issue, judges often schedule the harder cases for when they have more time. Could that be a factor in fewer decisions for parole later on? And is there a study as to whether more generous decisions for parole or earlier in the session are better decisions than decisions later during the session?
So yes and no. So yes, in the sense that I absolutely agree that this, and that's the point, that despite all the things that they control for in the study, there's always these other murky things that they can't control. So this issue of, for example, let's leave for the end the really complicated cases. And I think that makes a lot of sense. I've clerked on the court. I've seen judges saying, okay, we'll leave that for last. That's going to take a while. But you can't code for that, right? In an empirical study, they don't control for that. So I certainly believe that took place. I can't prove that it took place, but I certainly believe that took place, at least in some of the days there. And that's biasing the results. Follow-up studies and the quality of parole, and it's a great point in the sense of, at the end of the day, what we really care about is quality of decisions, right? To know, are these decisions good or bad? I'm not familiar of a follow-up study trying to evaluate time of the day and then seeing, I don't know, recidivism 5 years later. That would be an awesome study, but I'm not familiar with somebody doing that.
Thank you for all of those insightful answers, and I think we'll turn it back over to Mr. Cooperman.
Well, thank you, Professor Teichman, and thank all of you who are on this Zoom seminar for participating. I'm fairly confident that what Professor Teichman has discussed today resonates with our actual daily experiences in the practice of law. But now I think we have a better idea of why it resonates and why things happen the way they do. So thank you again, Professor, for your very fascinating talk.
My pleasure. Thank you very much for having me over tonight. At least it's for me here. It's
That's right. It's late.
11 p.m. in
Right.
the Holy Land.
Well, so just a couple of procedural notes here. All the participants today will be receiving an email tomorrow with a link to the evaluation. Please complete it by Monday of next week to secure your CLE credits. There will be one final CLE session in this series in a month on Wednesday, March 2, 2022, and the topic will be Copyright in the Holocaust, featuring Professor Michal Shur-Ofri. And for future programs and to learn more, you can always visit www.afhu.org. And again, thank you all for attending and listening in, and thank you, Professor.